Hi, my name is Liana Alia from Firm 2 YY and Co. As for today, my firmmates and I will be presenting our articles under the topic of conduct as evidence comparative analysis between Malaysia, Singapore and the United Kingdom. As the Latin lexic goes, semper necessitas probendi incubit igue agit, which means he who affirms must prove. This has been a general principle in putting a burden of proof to any cases in indicating the parties to a lawsuit that they are innocent. The Evidence Act 1950 has been the main legislation that governs the law of evidence in Malaysia, and it provides direction on how evidence should be established and presented to the court, as well as its relevance and effect, be it in criminal or civil cases. One of the ways evidence can be tendered, according to the Act, is through conduct of the accused person, the victim, or even a third party. This writing will be focusing on conduct as a whole, which includes the detail listed down below. Firstly, for Malaysia, Evidence Act 1950 is the legislation that governs law of evidence in this country, where conduct specifically is under Section 8, Subsection 2 of this Act. Meanwhile, for United Kingdom, it can be said that no specific legislation have been expressly mentioned on evidence of conduct. However, it can be argued that conduct as evidence is actually provided, but not directly under specific legislations. And last but not least, Singapore Evidence Act 1893 is the legislation that governs evidence law in Singapore. Conduct as evidence is provided specifically under Section 8, subsection 2.
Moving on, this part will discuss the meaning of conduct and the types of it as in three countries mentioned. The discussions will refer to the legislations that govern law of evidence and cases in each jurisdiction. In United Kingdom, Section 114 and 115 of Criminal Justice Act 2003 being read together, implied assertions, which also included implied assertions by conduct alone, is admissible. Implied assertion was defined by Justice Mason in Walton against R. Based on cases and commentary, it can be said that the United Kingdom is having two types of conduct as evidence, which are previous conduct and subsequent conduct. In the case of Manchester Brewery Convicted Encoms, it was decided obiter the evidence that specific customers ordered the beer, sampled it, did not finish it, and then departed or tossed it away would be admissible. In Malaysia, the word conduct in Section 8, Subsection 2 of Evidence Act 1950 is not being defined by the Act. Literally, conduct means behavior. There are two types of conduct, that is previous conduct and subsequent conduct. This is supported by what Federal Court Justice Zulkifli Makinuddin had said in the case of Ibrahim Muhammad and another against public prosecutor. For previous conduct, it refers to the conduct of a person, for example, an accused person before the commission of the facts in issue. For subsequent conduct, it refers to what an accused person, a victim, or a third party does after a crime has been committed. In the recent case of Muhammad Saiful Rizan bin Sainan against public prosecutor, the Court of Appeal upheld the learned trial judge's conclusion that the information given by the accused to the arresting officer concerning the whereabouts of the deceased, which led the police to discover the deceased, is relevant to prove his conduct under Section 8 of the Evidence Act. For Singapore, the Evidence Act 1893 does not provide any definition on what is conduct. Conduct has the meaning of the manner in which a person behaves, especially in a particular place or situation. Under the Act, there are two types of conduct, which are previous conduct and subsequent conduct. To illustrate this, in Su Emmanuel and Emmanuel Priya et al. N, it was held that subsequent conduct may also be relevant insofar as it is proof of the agreement made at the date of the law. For comparative analysis, for both Malaysia and Singapore, conduct as evidence is expressly provided under its legislation. On the other hand, it is not clear for the United Kingdom as there is no specific mention of the evidence of conduct in its legislation. Next, when it comes to the meaning of conduct, none of these countries have given a statutory definition under its legislations. Moving on to the types of conduct under each jurisdiction, in both Malaysia and Singapore, there are two types of conduct, namely previous conduct and subsequent conduct. For the United Kingdom, although it is unclear, it appears that there are also two types of conduct as evidence.
Next, we discuss the relevancy of conduct as evidence in criminal cases and also in civil cases. It must be noted that what is relevant may not be admissible and also vice versa. In the United Kingdom, the criminal cases referred to were E.G. and the governance of Debtors' Trust, whereby in this case, conduct of the accused was rejected because the conduct of the accused was doubtful and there were many other several complex issues to be considered. Second, in the case of FH and Secretary of State for Home Department, it was stated that there is a relationship between the time elapsed and the conduct of the accused, thus the offence committed must be taken into consideration. Now we look at civil cases in the United States Kingdom. In a civil case whereby the claimant claimed in the Court of Appeal on her conduct, which was the misauthorization of a COVID test, the Court of Appeal held that the conduct of the claimant is a determining factor to determine whether the appeal should be allowed or not. In Malaysia, there are many criminal cases which discusses conduct as evidence, such as in the case of Chandrasekaran, it is stated that subsequent conduct is relevant under Section 8 of the Evidence Act. Next, in the case of public prosecutor and Chia Liang Fong, it is stated that there has to be a nexus or a relationship between the act of the accused, which is the conduct, and also the offence committed by the accused. In another case, in the case of Chan Kwok Cheng and another versus the Queen, it is stated that on determining whether conduct as evidence is relevant or not is a question of law and is to be decided on a case-to-case basis. Now we look at civil cases. In civil cases, conduct is relevant under Section 52 of the Evidence Act, and this is acceptable under the case of Datuk Narakupalan, whereby stated that Section 52 and Section 55 of the Evidence Act is relevant. In Singapore, we look at the case of public prosecutor and Bong Sin Suan, whereby in this case, previous conduct or prior conduct is discussed. And in this case, it is stated that a previous conduct, although no offending charge has been given, should be considered and taken into account by the courts. In another case, in Chua Siu Pang and public prosecutor, previous conduct can be acceptable and considered relevant if it is related to the accused state of mind. Now we look at civil cases. In civil cases, in the case of Material Industry and Trade Singapore, it is stated that the conduct of the parties to the contract is relevant evidence when the courts determine and when the courts wants to give their judgment to the case.
Next, we will see on whose conduct is relevant. Conduct of a person related to a case is very important in deciding the actual person behind the scenes. So to decide that, firstly, there is a need to determine which party's conduct is relevant regarding the case. Whose conduct is relevant could fall under a very wide ambit where a few parties can be seen relevant to the case. First, we shall look into the United Kingdom's position, whereby it is impliedly stated under Section 114 of the Criminal Justice Act 2003, read together with Section 115 of the same Act, that conduct alone is admissible. According to the case of R versus Williams, evidence of motive and conduct is necessary to prove the fact of homicide by the accused as well as his afterthought. Besides that, in the case of R versus Wangbo, the court looked into the elements about the accused's conduct which crossed over between a leading role and a significant role. Now let's look under the Malaysian position, whereby Section 8 subsection 2 of the Evidence Act 1950 provides the explanation on conduct of any party related to the case is important and vital to the suit. So in the case of Parlan bin Dade versus PP, the court held that the conduct must be directly influenced or be influenced by a fact in issue or the relevant fact to constitute the conduct as admissible. In another case of Ravi Shankar Analaki and Paramarajan versus Muhammad Jasni bin Zainuddin and another, the court held that there are a number of criteria in determining which version of the evidence to believe, such as the demeanor of the witnesses, the consistencies of the answers given by the witnesses, the conduct of the witnesses, and other surrounding circumstances. Lastly, let's take a look into the Singaporean context, whereby the conduct falls under the Section 8 subsection 2 of the Evidence Act 1893, which provides that the conduct of any person or party to the suit is relevant and needs to be considered. According to the case of Lee Chi versus PP, it was stated to prove the common intention between the parties, the court must investigate the circumstances of the case to establish criminal act and to further see on pre-arranged plan which constitutes the conduct of the parties. So pursuant to the case of public prosecutor versus Boon Sim Suam Susanna, the court held that the accused knowledge arising from the uncharged prior offending conduct is important and relevant, and if such conduct is proved, it should be considered in sentencing as part of the total circumstances. So from here we can see that the three countries sees and views the conduct of any party related to the case, such as the accused or the witnesses, as an important conduct to be considered. So, whose conduct under the Evidence Act has no fixed details. If any party's conduct which is in who is involved in that case could be relevant to the suit, then the court must take further necessary consideration in deciding the suit.
In Evidence Act, mainly in Explanation 1 refers to Section 8, explain that conduct refers to action. A statement will not be part of conduct except when such statement accompanies or explains acts. Previous conduct refers to the conduct of a person, meanwhile subsequent conduct refers to action of either an accused person, a victim, or third party where crime is committed. In the case of R against Larry, the appellant was arrested on charges with kidnapping, indecent assault, and assault occasionally real bodily injury of a 9-year-old girl. To determine whether there was a material amount of corroboration in law, the court must convince that the evidence is independent and it helps to show the reliability of the corroborated testimony in the essential aspect. In Aziz bin Mohammed Dain against Public Prosecutor, the accused was charged and convicted under Section 376 of Penal Code for the rape of underage girl. It was held that for the victim's statement to be regarded as conduct of the victim under Section 8, Subsection 2 of Evidence Act, such statement must be accepted as complaint. In judgment such as Balwant Singh, the Court of Appeal decided that a witness cannot verify her own testimony and that independent evidence is necessary. For a statement to be a complaint, it must be made voluntarily without any element of inducement or intimidation. For the Singapore's case, in Krishna Jayaram and Public Prosecutor, the appellant was an assistant manager of the Banque Nationale de Paris, Singapore. He was charged and convicted of 24 counts of corruption under Section 6A of Prevention of Corruption Acts. On factual issues, the appellant challenged the conviction for the third category of charges. It was decided that when a person accused of corruption encouraged a witness to modify his statement, this was conduct compatible with a guilty mind and thus relevant to allegation of corruption under subsection E to Section 8 of Evidence Act. For comparative analysis, in Malaysia and Singaporean law of evidence, none to be discussed, with both countries adopt similar legislation. However, the law of evidence in United Kingdom does not emphasize thoroughly for statement as conduct. The finding from the research is independence evidence, which is statement from the witness, is required when concerning the accused identity. It must be noted that it is on the court to determine whether statements coming from the victim are independent or not. Therefore, it is certain that relevancy of statement of conduct is secured under Malaysian and Singaporean law, whereas in United Kingdom, the court holds the power to decide the corroboration of the statement coming from the victim.
Probative value of conduct as evidence. When a judge has to make a verdict on each case, especially during the prior stage, the judge needs to make a ruling whether to accept the evidence or not. Among all evidence laid down on the judge's table, the judge usually will classify those proposed pieces of evidence into the probative value. The UK case of R against Barry George involves Jill Dendlo, a TV celebrity who had been shot dead in 1999. This case had shown that the probative value of piece of evidence on source level hypothesis may be different from its probative value of offense level hypothesis. The relationship between source level and offense level hypothesis must be made very clear. And evidence should be evaluated against offense level hypothesis to have probative value and therefore to be judged whether it should be excluded from proceedings or not before the court. In Malaysia, the concept of probative value plays an important role as it is closely related to the concept of relevance in evidence law. The Junadi case had shown the importance of having probative value of conduct and character as the way to prove a piece of evidence. The principles used by the court are strong enough to acknowledge the existence of character evidence which plays a big and important role in the judgment of the case. For Singapore, the case Muhammad bin Qadar against PP stated that the reliability of the statements by the appellants was in question as it contravened the basic procedural requirements in the CPC, Criminal Procedural Code, and the Police General Orders, which the court said both statements were gathered in deliberate non-compliance with the procedural requirement. It leads to one conclusion that is clear. There is a need to adopt a fair trial as a basis for the test of admissibility, which must be limited to fairness that centers its attention on the outcome of the trial, and not fairness of the entire process of the trial, which shall not be questioned, while the judiciary has a duty to keep law enforcement officers in check and prevent courts from abetting or endorsing flagrant improprieties by the police, or to be perceived as indirect instruments of illegalities.
We can see that each country between Malaysia, the United Kingdom and Singapore has their own take on conduct as evidence. As for the meanings and types, Malaysia's Evidence Act 1950 and Singapore's Evidence Act is in pari materia, which it can be seen in the Section 8 itself. Meanwhile, although the United Kingdom did not have a specific statute for conduct, they discuss it in the Criminal Procedure Rules 2020 and Criminal Justice 2003. To cater the issue of conduct, however, the types of it is unclear, while literal meaning is given for the term conduct. In addition, for whose conduct is relevant, based on our research made, all three countries have similarities whereby conduct of any party to the case is very important in making sure the case is decided right, regardless of previous or subsequent conduct, as long as it is relevant to the case. Conduct as evidence is relevant for both criminal and civil cases, where a lot of cases were referred to. Additionally, in discussing relevancy of statement as conduct, statement from witness given straight by victim to a third party, considering they said it themselves, is needed. However, it's a different case for the United Kingdom. The court has the power to decide the corroborations of the statement coming from the victim. Based on this research, probative value of conduct and character as evidence is very crucial part that exists as a way to prove evidence, as it can rationally affect the assessment of the probability of the existence of a fact in issue. All in all, we can see that every country that we study has a comprehensive provision for this topic, where judges take into consideration the act of conduct when deciding a lot of cases. That's all from us. Thank you.